Hey everybody, Derek Christensen. Today I wanted to talk to you about my 10th horror story in estate planning. This one is an interesting one because somebody decided to air their dirty laundry in legal documents and it got exposed. So before I dive into that, I wanted to let you know how to reach out to me. You can email me directly, Derek, D-E-R-E-K, at legionlawpllc.com, or you can find me at my website, www.legionlawpllc.com. So with that, let's dive right into this interesting story. So, I'll give you a pro tip. Legal documents are not the place to air your dirty laundry. If you are having family disputes, if you are upset at your wife, if you are frustrated with how life has treated you, this is not the wills, trusts, powers of attorney, those are not the places to put that in writing because, as you may know, these documents are used later on to determine how do we split things up. How do we treat you while you're still alive? All sorts of things. And people need to know the basic information about the legal rights and the legal distribution of assets. That's all they're looking for. And unfortunately, people I have seen, never in my wills, don't get me wrong, I never let this happen, but you never, ever, ever want to put into a legal document why you're making a decision, if that decision is based in negativity. So more specifically, I would see wills that say, I give 1/2 to child A, I give 1/4 to child B, and I give child C's 1/4 to a charity because child C didn't call me on Thanksgiving and no longer cared about me in my latter years, and I never saw them at Christmas. And just don't do that. Don't do that, because at the end of the day, it's going to embarrass those people. And embarrassed people, angry people, frustrated people are going to feel, understandably, negative emotions. And people, when they experience negative emotions, act out at times. In the legal context, acting out includes suing and lawyering up and trying to bust everything up. In a will situation, if you have 50 to one person, 25 to another, and 25 to a charity, when there's that last person who didn't receive anything and they're insulted, if they successfully bust up the will, in other words, if they prove that the will is not valid and it shouldn't be applied, then the default laws of Texas will apply. And the default laws in that circumstance would say 33% to each of those kids. So that last kid, C, has nothing to lose. They have nothing to lose and everything to gain by suing and busting up your will because you embarrassed them. So I'm sure they're already going to be frustrated at the concept that they're not receiving a penny, and I'm sure they're going to be very, very incentivized at that point to say, I'm going to stick it right back to you because you stuck it to me, you know? So either way, simply just write it down. It's already bad enough that you're disinheriting your loved one and they're going to be insulted and offended by that. It may be, I don't know, I can't speak to them, but if they are insulted and offended, trust me, explaining why that's the case is certainly not going to help anything. So if you're really looking for some kind of way to vent this, I would recommend two things. Either A, get a journal and just keep it to yourself. Don't put it anywhere in writing in legal, or put it in writing on your journal, but don't put it in your wills and binders and trusts and stuff. Or if you're feeling very, very ambitious, you can technically include a letter to your loved ones where you simply explain, this is why I made my decisions, this is what I'm hoping you do with my assets, please, this is my final wishes for you, I wish you farewell, blah, blah, blah. You can write that down and type it out, sign it at the bottom, whatever. It's not a binding document, and just include it in your documents that you generally keep together for your estate plan. That even then, that letter is still not really recommended because, again, it's kind of insulting to others if you're creating a scenario that could be interpreted as insulting. Now, again, if you're already giving 33 to each of the 3 kids, then that letter doesn't cause any harm. So go ahead and do it. Or if you want to include something in your will, it's still inappropriate, but it's better than insulting them, right? So just, again, legal documents are for legal things. We don't care about the emotional stuff. Attorneys are supposed to just turn that switch off whenever we go into court. So if a judge reads this, they're going to say, well, I don't care why they did something. I just care that it's written down, and that's it. So if it was written down, executed correctly, it's going to happen, but you don't want to incentivize others or anger them or embarrass them into getting back at you. So either way, that's one of my thoughts on that are, welcome to do a letter. I think a journal is probably the best option, though. So with that, if you have any other questions about how to vent your frustrations with your family and your estate plan, feel free to email me directly, Derek, D-E-R-E-K, at legionlawpllc.com, or you can find me on my website, www.legionlawpllc.com. So with that, have a great day.